Ladies and gentlemen, this is Gail Morgan welcoming you to the Libertarian Counterpoint's Knuckleheads of Liberty podcast. You've heard their point, now listen to the counterpoint.
Welcome to the Knuckleheads of Liberty. We are coming at you on August 25th, 2021. About 8 months of stumbling through Democrats and Biden's clinic on how not to govern a country. But before we get into any of the issues, let me introduce you to our panel today. In our upper left-hand corner, we have Leon, the word Brathwaite, last word in Liberty. He is a retired engineer in the state of California. In our lower right-hand corner, we have our screaming eagle of freedom, Tim Everett. He is a pilot in the state of California. In our lower left-hand corner, we have a special guest with us this time, Sam Paredes he is a director of Gun Owners of America. And so he is joining us to comment on some of the Second Amendment issues we'll be talking about in the show. And my name is Jason McPhee, and I'll be your host today. So let's jump right into the topics. James, if we could get on the screen here, first topic is the Supreme Court in about a month or so ago agreed to hear one of the first major gun cases, Second Amendment cases, in quite a while. And a lot of this has to do with the change in the dynamics of the court after the Trump administration. The court is a little bit more conservative now than it was before. And so it's a little bit more friendly to the Second Amendment. And so this case is involving, some of the challenge to some of the laws in the state of New York. And I don't know if, Sam, you're probably a lot fresher on this than I am. So I don't know if you wanted to get into some of the details of this case.
Sure. The New York State Rifle and Pistol Association filed a lawsuit against the city of New York because of their draconian concealed carry weapons permit laws and regulations. They actually have a law in the book that would allow them to issue them, but in fact, they don't issue them except to very few people and not to the general public. And they demand that you issue give them a reason as justification as to why you need a concealed weapons permit.
Right.
And even with good reasons, they traditionally and typically do not issue these permits. So in New York, you're only allowed to have your guns in your home, traveling to and from a registered gun range, or traveling outside of the city to take them hunting or target shooting outside the city or for any lawful means. But that's it. You're limited to that. In some cases, they allow you to have them in your businesses, but that's all. So the Rifle and Pistol Association filed a lawsuit. The Court of Appeals of that area, of course, denied that citizens have a Second Amendment right that allows them to carry firearms, that allows them to bear firearms. Remember, it's the right to keep and bear arms. Keeping means having them in your homes, in your businesses, and bearing arms means to be able to carry them in public. That's part of the Constitution. And so the case was initially filed against, it was called NYSPRA versus Corlett, and then the district attorney changed, and now it's Bruen, Bruen. So it's New York State Rifle and Pistol Association versus Bruen. So it challenges the laws that give the law enforcement officers of the city of New York total, unvarnished ability to decide who they're going to give a CCW to and who they don't. And typically, if you're a law-abiding average citizen, you're not going to get one. If you're some high-profile, connected person, maybe you'll get one, but that's it. So there's a 14th Amendment problem with that of equal protection under the law.
Yes.
And we know that the right to keep and bear arms. People might remember 12 years ago, the Heller versus Washington, D.C., where the Supreme Court ruled that the Second Amendment is an individual right, not a corporate right, to allow for a state militia, a state National Guard, or anything like that. It was an individual right. And then the court knowing that applied only in federal enclaves, 2 years later, they ruled in McDonald versus Chicago that right was so important that they incorporated it to all citizens and would prevent state and local communities from infringing on that right as well, thereby taking the argument of, the 10th Amendment. We have states' rights. We can do whatever the heck we want to do that isn't addressed in the Constitution. Well, the Supreme Court said, yes, it is addressed in the Constitution in the Second Amendment. And no, you don't have a state right to infringe on Second Amendment rights of citizens. But since then, there have been many, dozens and dozens of lawsuits filed as states and cities and counties have violated that ruling. And many of the appellate courts, they have this, they don't agree, believe it or not. Appellate court justices who don't believe in the Constitution and the meaning of the words in the Second Amendment. And they kind of let policymakers in cities and counties and states with the wink of an eye. You go ahead and send us whatever you want to do, and we will find a way of making it constitutional for you. And in doing so, they use three types of levels of scrutiny. One is rational basis. That means whatever logical means they can come up with justifying a law makes it constitutional. One is intermediate scrutiny, where there has to be a heightened level of government interest in a particular issue in order to for the government to allow the government to infringe on a Second Amendment, on a right. And then finally, there's strict scrutiny. That means that the state has to show a very specific interest in them wanting to infringe on a constitutional right, and their response to it has to be very narrow, only to address that issue. So these courts, they've used that as a giant tunnel that allows multiple side-by-side 18-wheelers to drive through it, passing all of their gun control laws. And in some appellate courts throughout the country that tend to be a little more freedom-loving and defending of the Second Amendment and the Constitution in general, they've ruled against these types of laws. So we have this judicial crisis where we have freedom and liberty in some appellate court districts. All of the states that are under that appellate court ruling, the laws apply to them in that way. And then places like the Ninth Circuit, where we have 11 states, 14 states, a bunch of states, and we have to live under the rules passed by the appellate court, and our freedoms are way different than those of Texas and Oklahoma and places like that. So the primary job of the United States Supreme Court is to resolve issues of controversy between appellate courts. We have that issue of controversy, and they have to take a case. So they accepted this case. And people might remember that New York State Rifle and Pistol Association filed another lawsuit a little earlier on, and the Supreme Court accepted the case, and then they ruled that it was no longer valid. They mooted the case because the city of New York changed the laws. The state of New York passed a law that said that the city of New York could not go back to the laws that were being challenged by the Supreme Court. So they resolved the issue of conflict, and therefore the Supreme Court felt that they could not take the case on because the conflict was resolved without them having to take issue. But I think that some of our more rational members on the Supreme Court wanted a clear-cut, clean case where they can come up with a definitive ruling on the Second Amendment. And we have 5 judges who have in the past either ruled or published statements that they believe that the Second Amendment should only be judged by the text, history, and tradition of the meaning of the words when they were signed into the Bill of Rights and ratified by the states. That one day after that, if the definition of the terms changed, or a week after, or years after, or decades after, or 100 years after, the definition that can only be used is that was used when it was written. and we are totally supportive of that. And if the Supreme Court rules and gives us scrutiny, gentlemen, we're going to have the greatest opportunity to fight to restore the Second Amendment nationwide. Many gun control laws will fall by the wayside because they cannot stand that level of scrutiny. So,
well, Sam, I have a quick question for you. Though you were getting into definitions there, and one of the things we hear often from the left is when they talk about the Second Amendment, they use the phrase "well regulated." And so, how do you square that as far as with the rights to open carry and everything else? Certainly, these are arguments that we hear from the other side that it would help to hear your expert opinion on what that means.
Well, I agree with the Supreme Court in Heller versus Washington, D.C., where Justice Scalia clearly addressed what they felt was the meaning of well-regulated. First of all, he pointed out very systematically that the Second Amendment is actually two statements. One of them is a prefatory statement that establishes the goal of the active portion of the amendment. And so well-regulated back in the day did not mean full of laws and controls and regulations and restrictions. It meant that people would train themselves, would use the experience that they've gotten from their own lives and be able to bring that experience, if asked to stand as a part of the militia to defend this country or defend the state or something like that. Now people say, well, that constitutes the National Guard. No. According to federal law, the militia is made up of all law-abiding, capable citizens of a certain age forward. All citizens are a part of the militia. So for them to say that it only referred to the National Guard is specious. It's a twisting of the meaning of the words. So the active part was, the right of the people to keep and bear arms shall not be infringed.
Yes.
Period. Infringed. What is infringe mean? That means that the government cannot do anything to stand in the way or prevent law-abiding citizens from utilizing their Second Amendment rights to acquire, own, possess, carry, use firearms in a lawful manner. It doesn't cover anything that is criminal. It covers everything that is legal, and that's what shall not be infringed mean. And of course, the leftists, the one or two or maybe half of the leftists that might be listening to this broadcast might say, "Oh, that's terrible. That's inflammatory. That you're you know what? Freedom is freedom. Liberty is liberty."
Exactly.
And you get what comes with that. And the vast majority of the impact of freedom and liberty is nothing but good. It's a flourishing and growing populace of people who are free to enjoy their families, their churches, their vocations, their avocations, or just no time but sitting on the couch watching TV if they want, because they're free to do so. And when you have the government that tells you you can't do any of those things or they control any of those things, that's called infringement. And that's what we are fighting against.
Yeah, if I could throw something an additional. Yeah, the most common example of something that was well regulated was something that was in good working order. It worked really well. So back then, they would say that a clock was well regulated, meant that it told time accurately, or fairly accurately for the times at least. And so, as Sam points out, when you're talking about a prefatory clause like in order to have this well-regulated or good, well-functioning militia, then you have the active clause that says that in order to do that, we have to have people in the United States. They have to have the ability to keep and bear arms. how else are they going to get well regulated? How else are they going to become a good functional militia if they're not out there practicing and able to carry and utilize their own firearms in day-to-day activities? So there you go. I mean, that's
well said, Tim. Well said.
Okay, thanks.
And Sam, you were talking about being free. I think one of the aspects of being free is that we should never have to ask the government for permission to exercise our God-given rights.
Leon, you are absolutely correct. If you have to ask for permission, if you will be denied the ability to exercise a constitutional right unless you comply with some sort of government requirement,
right?
That is not freedom. That's like saying, reporters, you have to go through a background check before you can become a reporter. And if your background check comes back with any problems, you don't have the right to be a reporter.
Right.
And you're going to be, have to pay these fees, and you're going to have to buy insurance policies before you're allowed to write an article or do a story on video or something like that. People would say, that's crazy. That is totally and completely contrary to the First Amendment.
Yes.
And you know, when we want to get together with our folks at gun shows to talk about freedom and liberty and guns and shooting and hunting and target practice and tactical training and defense training, and the government says, no, you can't use public facilities to have these abilities to assemble. It's not just the Second Amendment, but the First Amendment as well that they are violating. So we're actively working in challenges against those types of things. But you're right, Leon. You're absolutely correct.
It's funny because you used an interesting analogy when you equate, I guess, the idea of the press needing a license to do their stories versus the other. And somebody on the other side might push back. Well, but the person with the gun has there's so much risk they're imposing on other people. But my gosh, think of all the risk that's been imposed by bad media and fake news in the last couple of years. I mean, fiery but mostly peaceful protests.
Yeah, tell me this again. Yes.
People have died as a result of articles, of stories, especially when they're totally false. But yeah, lives. You want to talk about lives being involved? That's the same thing. So, stop talking out of both sides of your mouth, and you either believe in freedom and liberty or you don't. And it goes from the First Amendment to the 10th Amendment and on to the rest of the Constitution. So,
well, maybe we should have some kind of registration and schooling required for people before they can go protest. Yeah. Is that what you think,
Jason? Yeah, you can protest if the government allows you to protest. It gives you permission, which is actually happening in Australia right now, actually. So
is that right? Yeah.
They're arresting people for leaving their homes in Australia right now.
Yeah. Australia has become the new best place to never go in the million years.
Yeah. Well, I want to push us on to the next story before we run out of too much time here. I wanted to get Sam's thoughts on the appeals court recently blocking a federal judge's ruling to overturn California's assault weapons ban. And this is something we hear. It's an assault weapon because it looks scary, and I guess what is an assault weapon anyways? Are there assault knives? Are there assault frying pans? I don't know. So anyways,
Jason, that's a great question. First of all, the term assault weapons is a term that was coined by the California State Legislature in 1989. Prior to that, the term assault weapon cannot be found in any lexicon of military or firearms since the creation of the world. Yes, you found assault rifles, and that had a very specific definition. But the legislature wanted to demonize what they considered to be scary-looking guns that you could see in the movies shooting themselves and shooting thousands upon thousands of rounds of ammunition held by some skinny little girl. And and killing everything and everybody around them and knocking down buildings and stuff like that. So understand that the term assault weapons is a politically generated term. It is not a term that has any definition. What is it? You could go by the definitions that they've tried to create, and it doesn't include just these black guns that are on the screen, but it includes a lot of guns that people use every day to hunt, to target shoot, or to just collect across the country. Judge Roger Benitez of the San Diego Federal District Court issued a ruling against the challenge against California's Assault Weapons Control Act. He did a masterful job of looking into the history and the common sense that the assault weapons control ban violated as a law in the state of California and declared it unconstitutional. As a matter of fact, this is the kind of logic that he used. Oh, so you have a firearm that it has a collapsible stock, an adjustable stock. It can shoot various types of ammunition. It can have different configurations with long barrels or short barrels that make it easier, simpler, and more accurate to shoot for a wide variety of the population. Little people of little stature, women, youngsters, all the way up to elderly people and everybody in between. You can configure these guns. It's the Barbie doll of guns in order to make them more accurate, more efficient for public use. And you are banning it because of those characteristics. And so you're saying you want the public to have guns that are harder to shoot, that are more difficult for people to be able to utilize to defend themselves. But the fact that criminals don't comply with the laws, as a matter of fact, that's why they're criminals, because they don't comply with the laws.
Exactly.
They use whatever the heck they want. They configure their guns in any way that they want to make it easier for them to be predators against the law-abiding citizens whom the government has prevented from making firearms more capable for them to use. They lie about the calibers. The .223 is not a high-powered cartridge. It's at best a medium-powered cartridge that is generally a varmint caliber, but it's easy to use effectively and accurately, which makes it a good choice for a vast majority of people to use as a self-defense weapon. And Judge Benitez came up with a great ruling. Of course, the Ninth Circuit Court of Appeals, it was appealed by the Attorney General to the Ninth, and now they've assigned a 3-judge panel to review Judge Benitez's ruling. He declared the law unconstitutional, flatly unconstitutional. Right. Now they're going to evaluate whether Judge Benitez was off his rocker or if they agree with him. And of course, in previous lawsuits and cases involving magazines and ammunition, 3-judge panels, the Ninth is not the nutty Ninth like it used to be, thanks to President Trump, who has appointed so many judges to the Ninth. It's almost an equal balance of judges who believe in the Constitution and those who don't believe in the Constitution. So we've been blessed with having 3-judge panels that had conservative judges on them, and they've ruled ammunition laws, magazine laws unconstitutional. And every time the Chief Justice, who is a rabid anti-gunner, has asked for an en banc hearing, in other words, taking the ruling of that 3-judge panel, wiping it out, holding another hearing with 11 judges sitting on the panel, and he's been lucky enough to have a majority of liberal judges on those panels. And I think that the judge kind of puts his thumb on the scale, because they're supposed to pick the members at random. He's the only one that is not a random choice for those en banc panels, but the en banc panels have overturned Judge Benitez on multiple occasions, and then we say, okay, that's a stumbling block, and from there we go to the United States Supreme Court, and let's see what happens.
Indeed.
Well, we are getting close to the end of our show, and so I think I'm going to take it to our Knuckleheads of Liberty, but won't be what we were planning on it, because there's another topic I wanted to cover, and that's this idea with essentially the idea that the Second Amendment, one of the purposes is to allow for citizens.
Jason, could I interrupt one quick second?
Yeah, yeah.
What about good guys with guns? We're not going to let them do that?
Well, we're running out of time.
That's okay. That's okay. We can do it later.
Yeah. So anyways, but this is a topic one we've talked about before, but I think it's so apropos, especially since we're focusing on the Second Amendment with this one, and that's the idea that guns are a way that the citizens can sort of keep the government in check to a degree, an oppressive government. And earlier in the year, Biden had made a statement. He said, those who say the blood of and then he said the blood of patriots, and all the stuff, how we're going to have to move against the government. Well, the tree of liberty is not watered with the blood of patriots. What's happened is that there have been, if you wanted or if you think you need to have weapons to take on the government, you need F-15s and maybe some nuclear weapons. And, we're seeing right now in front of us, he's essentially fighting cavemen in Afghanistan and he's running.
Yeah. Well, if I could quickly interrupt, he's trying to quote from Jefferson, and Jefferson's
trying.
Yeah, the tree of liberty is watered with the blood of patriots and despots. I wonder why he left that out. Yeah. Why? Well, because you're a despot, you dummy.
Yeah. You know what?
Go ahead.
You're exactly right, Jason. Look at Afghanistan. This is a country that has never been conquered. Alexander the Great couldn't conquer it. The Russians couldn't conquer it.
Yeah.
They had nuclear bombs. They had jet airplanes. They had everything. The United States, we've lost. We had jet airplanes, nuclear bombs, high-tech weapons and stuff like that. And a bunch of people who started out by manufacturing their own guns. The Dara people of Afghanistan and Pakistan were making guns in caves using hand tools that were virtual duplicates of the guns that they were fighting against, and they've succeeded in pushing back this military that has every advanced weapon available to them, and they won. So for them to say that Americans with the guns that they pull out of their own closets to fight against tyranny in America are an ineffective group of people, boy, they don't remember the words of Admiral Yamamoto, who said, "We will never invade the west coast of the United States, because behind every blade of grass will be an American with his own gun to kill us."
Indeed.
So that's what we are.
Yeah. Well, before we leave, I wanted to give one more chance for you to talk about your organization real quick, how people can connect with you if they want to get involved with defending the Second Amendment.
If you want to be involved in the Second Amendment, go to gunowners.org, gunowners.org. That's Gun Owners of America. It covers Washington, D.C. and everything that happens there in 49 states throughout the country. If you want to be focused on California and what's happening, go to gunownersca.com. And we have a extra special organization here, because what happens in California will either affect or infect the rest of the country, and that's why we have a very strong presence here. So we invite everybody to be involved. As we say, we want you to be armed and informed. Join Gun Owners of America and Gun Owners of California. Continue to follow Knuckleheads of Liberty. These guys, you're a shining beacon of light, of truth and common sense and logic out there that people need to be listening to, and I am honored and proud to be on with you guys.
Well, thanks so much. And by the way, we're coming out of California, no less. So that's quite a miracle in and of itself. But thank you all so much for joining us today. Sam, thanks for participating today, and we hope to see you all next week. Until then, stay free.
All righty.
Bye. Indeed. Bye.